lawyers, does anyone remember the trillion VND divorce between coffee giant Trung Nguyen Group's chairman and his wife, which has caused a heated controversy since 2019, 2020, and shows no sign of ending? A notable detail in this case is that the plaintiff asks the defendant to fulfill its child support obligation by shares instead of asking for support in money like in other common divorce cases. This request raises many legal issues that the current law does not fully regulate, posing issues that need to be studied further. Whether child support by stock is legal? Clause 24, Article 3 of the Law on Marriage and Family 2014 provides the following: support means an act whereby a person has the obligation to contribute money or other kinds of property to meet the essential needs of another person who does not live together with but has marriage, blood or raising relation with the former and is a minor or an adult who has no working capacity and no property to support himself/herself, or meets with financial difficulties as prescribed by this law. Thus, the law allows a person carry out his/her support obligation by contributing money or other kinds of property. But the law on marriage and family does not specify the phrase other kinds of property. Clause 1, Article 105 of the Civil Code 2015 clearly states that property comprises objects, money, valuable papers, and property rights. In which, property rights are rights which are able to be valued in money, including property rights to subjects of intellectual property rights, right to use land and other property rights. In essence, shares can also be considered as property rights due to the fact that shares are the charter capital divided into equal parts in a joint stock company. Shares are valued in money and their market price is the highest trading price on the market the previous day, the price agreed between the seller and the buyer, or the price determined by a professional valuation organization. There are many different types of share. Shareholders have rights and obligations corresponding to the type of share they own. Thus, if the share has a property value, the owner of the share has the right to that property. Currently, the law also does not prohibit child support by shares. Therefore, child support by shares is not contrary to the provisions of current law. In case the company's business is profitable, the shareholders are paid with dividends. The person who receives the shares may enjoy the benefits from the company. But if the business makes a loss, the person who is awarded the shares will not receive a specific material benefit, then it cannot be considered a support. Will the supported person the obligations in proportion to the percentage of shares to be supported? The nature of child support after a divorce is that the parent who does not directly raise their children provides support for her/his minor children and adult children who have lost their civil act capacity or have no working capacity and no property to support themselves. The ultimate purpose of child support after a divorce is to ensure the rights and interests of the children, specifically in material aspects to ensure that the children's basic needs are fully met. When the requests for child support by shares is voluntarily agreed upon by the parties or recognized by an effective judgment/decision of a competent court, the supportee will receive the benefits through the shares and become a shareholder of a joint stock company where the supporting person has shares, because shareholders are individuals or organizations that own at least one share of a joint stock company. Shareholders in a joint stock company have the rights specified in Article 115 of the Enterprise Law 2020, but also have certain obligations as prescribed in Article 119 of the Enterprise Law 2020 as follows: 1. Fully and punctually pay for their subscribed shares. 2. Do not withdraw contributed capital in the form of ordinary shares in any shape or form, unless the shares are purchased by the company or other persons. The shareholder that withdraws all or part of the share capital against regulations of this clause and persons with related interests in the company shall have a liability for the company's debts and other liabilities which is equal to the value of the shares withdrawn and the damage caused by this action. 3. Comply with the company's charter, rules, and regulations. 4. Comply with resolutions and decisions of the Board of Directors and the GMSs. 5. Protect the confidentiality of information provided by the company in accordance with the company's charter and the law. Only use the provided information to perform and protect their lawful rights and interests. Do not spread or share information provided by the company to any other organization or individual. 6. Other obligations prescribed by law and the company's charter. That means, when being supported by shares, the supported person is entitled to material benefits such as dividends, and must strictly comply with and perform other obligations according to the charter, internal regulations and regulations of the company and in accordance with the law. Child support is the granting of rights and benefits to someone rather than binding on them certain legal obligations, unless agreed to by that person. But the law on marriage and family so far does not have any provisions on whether parents must consult their children or need their children's consent regarding support. Therefore, although the law does not prohibit child support by shares, giving children obligations along with the benefits from share support seems to be going against the nature of child support. So, how to handle the case where the child does not agree to bear the obligations but only wants to receive benefits from the support according to the court's ruling? In the process of divorce settlement having dispute over the issue of support by shares, is it compulsory to consult the children? Currently, there is no specific regulation to clarify this issue. Conditions to receive dividends, material benefits from share support. If the supported shares are fixed participating preference shares, the children will automatically receive dividends regardless of the company's business results. But in case supported shares are not fixed participating preference shares, the dividends received will be based on the profit of the joint stock company. As a result, whether or not the child is entitled to a dividend depends on the type of shares supported and the net profit of the company. This support can be compared to a game of chance. Unless in lucky case the children receive the dividend, not only will he not receive the dividend but will also have to fulfill legal obligations related to the supported shares. Furthermore, if the company goes bankrupt, the support shares will no longer exist. The supported person is liable for the debts and other property obligations of the enterprise. They are even liable for debts corresponding to the shares owned. In addition, the support is done by the method of one-time support. So after the bankruptcy of the company, does a parent who is directly raising the child has the right to request a change in the level of support because of the absence of support shares? Difficult to enforce. Child support by shares is not prohibited by law and is not contrary to social ethics. Therefore, if parents agree on child support by shares, the competent court shall consider and recognize the agreement of parents with the support. But supporting by shares are not always beneficial to the child, they sometimes bring obligations. In addition, in case parents have agreed on this issue or the court has ruled on this issue, but the transfer of shares of the supporting person is limited, the judgment will be difficult to enforce, because common shareholders have the right to freely transfer their shares to others, except for the cases specified in Clause 3 of Article 120 and Clause 1 of Article 127 of the Enterprise Law 2020. As such, the transfer of shares will be limited in cases as follows: within 3 years from the issuance date of the Certificate of Enterprise Registration, the shares of founding shareholders may be transferred to other founding shareholders and may only be transferred to a person that is not a founding shareholder if the transfer is accepted by the GMS. In this case, the transferor does not have the right to vote on this transfer. The company's charter has provisions restricting the transfer of shares which are clearly stated in the shares of the respective shares. One of those limitations makes child support by stock unenforceable. Therefore, child support by shares is not just about an agreement between parents, but sometimes also requires the consent of shareholders in a joint stock company in certain cases. This makes it difficult to enforce the judgment even though the judgment debtor voluntarily executes the sentence. In addition, when the judgment debtor does not voluntarily execute the judgment, the competent judgment enforcement agency can only apply the coercive measure of judgment enforcement, which is to force the judgment debtor to transfer shares as support when there is a petition for judgment enforcement. Voluntary judgment execution, as analyzed above, is already difficult to implement, but if they do not voluntarily execute judgments, it will lead to more difficult enforcement. In case the judgment debtor fails to perform the obligation to perform certain tasks according to a judgment or decision, the enforcer shall decide to impose a fine and set a time limit of 5 working days from the date of issuing the sanctioning decision for the judgment debtor to perform the judgment enforcement obligation. If they fail to do so, the judgment debtor may also be examined for penal liability for the crime of not serving the sentence with a prison term of up to 5 years. In case the support is part of the judgment/decision of the first instance court, the judgment must be executed immediately even though it may be appealed or protested. Therefore, the spirit of the law seems to be showing that alimony is necessary to ensure a stable life for the supported person. But the prolonged or impossible enforcement of the judgment can seriously affect the rights and interests of the supported person. It can be seen that child support by shares is not prohibited by law. Is not against social ethics, but it is difficult to enforce in practice. Thus, the current law needs additional provisions to clearly define the following issues, supplementing regulations on the will of children in receiving shares as support property in divorce cases, determining which types and conditions of shares to be considered as a type of support property in divorce cases to avoid the case that the shares do not bring material benefits but bring obligations to the supported person. Specifying the implementation of court judgments and decisions on the issue of support child in order to be enforceable in. The purpose of child support in divorce cases is to ensure the interests of minor children or adult children who are unable to work and have no assets to support themselves. Therefore, the disadvantages of share support mentioned above may fail or even change the nature of child support after divorce. There should be more specific regulations on this issue we mentioned above to ensure the rights of the supported person as well as to ensure its meaning in real life. Thank you for watching. Please like, share and follow to update more useful legal information with FDVN lawyers. Goodbye and see you again.